Timing was right for my two guests to get together. That's a better open.
The Dan York State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
Welcome in. You're seeing this on Monday evening. A program note, and just for full transparency, we recorded this program on Thursday, a production schedule, and a couple of days off, and all that kind of a thing. And of course, if we're not here on the same day, we're not going to make commentary on contemporary issues. The news cycle moves way too fast in Washington and here at the State House. Obviously, we are done with our primary candidate discussions, and we'll pick that up in the general election. And we'll catch up, I guess, to the results of the primary on Thursday, since our Wednesday program is always, every day we record early in the afternoon, so that'll be the first time we'll be able to reflect on the primaries. I will note, for those of you who were able to see the Friday program with Representative Ehrenberg, I noticed, I mentioned to you that I was wide-eyed, I was dilated. We're recording on the same day. I think it's getting better, but I'm not looking at the lights. I'm sure that I'll be like this, though, by the time my two guests get done with each other, because this is a conversation that I think I think it'll be informative, because there's two different points of view and some stipulations and some facts which seem to be hanging out there in the balance. So welcome in. Thanks very much. So let's get to it. So both Mike Stenhouse from the Center for Freedom and Prosperity and Bob Walsh, the Executive Director of the National Education Association, meaning one of the major teacher unions, have been here in the last week and a half or so, opining about an issue and seeing it very, very differently, and kind of talking at each other. So to their credit, they're going to be here to discuss. So let me throw the headline up, which kind of it sets the table. This Janus decision, which really changed the way public employee union members will decide to or not to pay their dues. The simple explanation is that the Supreme Court made a decision that really created an all-or-nothing scenario for union members. In the past, union members have been able to deduct what they think is the political and charitable donation portion of their membership dues, which is about 15%, I believe, and still pay for and get the benefit of collective bargaining. What the Janus decision does is and Bob will explain his point of view on this, kind of dictates that the entire operation of the union is free speech, and like, if you want to pay and belong to the union, pay the freight. But no longer is there a percentage deduction. So now the Center for Freedom and Prosperity has been doing a campaign that suggests that union members ought to be aware that they can opt out. Whether that's fair or not, we'll let these guys kind of dig into that. But there were a couple of things that were at the core of the conversation. One was a memorandum that's going out by some of the local school district representatives to their teachers about negotiations, and specifically who gets to represent who where. So here's Mike and I a week and a half or so ago talking about that first. The point of contention, and the thing that I was wondering about, is in this directive that we were reading from in that last segment, was this notion that not only would you have to pay lawyer fees for representation. That's the wrong one. We're going to reset that one. Here's Mike and I. That's Bob, but you'll see Bob in a second. Here's Mike and I talking about this originally. Warns members of that local teachers association that they won't be able to vote on union matters, that you cannot attend union meetings or functions. Building reps will not attend meetings to represent you. If you file a grievance, you'll need to pay a union attorney, and outside lawyers aren't allowed to represent you.
That's false.
That's false.
False.
Not according to the law. You say that's false.
Well, it's deceptive. Deceptive in that the contract language may state that you can only use union lawyers if you file a grievance through the union grievance system, but employees have the right, still our equal opportunity laws still are apply, and they can go outside the process and use their own private lawyers if they choose.
Okay. So I talked to Bob about it a couple of days later, and he was emphatic. point of contention, and the thing that I was wondering about is in this directive that we were reading from in that last segment, was this notion that not only would you have to pay lawyer fees for representation, you must choose us, meaning union lawyers,
that's absolutely true, because we are the exclusive representative. Because what we don't want is someone like Mike Stenhouse, who claims just to be an innocent babe in the woods trying to notify our members of their rights under the law, when he's really all about trying to break the union, except for his union, which gives him a pretty good pension for 2.5 years of work. But we'll talk about that if he ever agrees to debate.
Means you're talking about his baseball pension.
Yeah.
Yes.
Well, he did 2.5 years of seat time against third. No, that was his dad. He was mediocre.
You want to resolve that part first?
I wore my Red Sox tie in Mike's honor today.
So Mike and Bob.
Mike's interpretation of the letter that was sent to the Bristol Warren members is incorrect. I stand by what I said on the show. I stand up, and we'll reiterate it now. You might even have a graphic on it provided by Mike, because someone gave him a copy of our letter or gave it to somebody that got it out in the media. And let me read directly from it, because the truth is the truth. If you want to file a grievance, you will need to pay a NERI attorney. This is if you're not a member. Please note that no, it's not false. Please note that outside lawyers are not permitted to represent you separate from NERI in grievance proceedings, as Bristol Warren remains the exclusive bargaining agent. Now, you want to hire a lawyer to go before the Rhode Island Department of Ed? Which lawyer? Bring them on. Bring them on.
I have a lot of them.
I have a lot of lawyers on this.
I thought this would be I thought this would be the defining debate. Now I got to get another lawyer.
Incorrect.
We need to make a note of that.
Exclusive bargaining agent. You're giving bad advice, and you could get sued for that by giving people bad advice. If you tell them they could bring in an outside attorney for an internal grievance procedure, something covered by the collective bargaining agreement for which we are the exclusive representative, that's absolutely incorrect.
All right.
Can I say something?
Of course you can. And then we'll try to regroup as to where each of you.
First, let me set the stage.
Get your logic here.
You know, our question is, why are the unions, their friends in government, want to keep their employees and workers in the dark? Why do they want to give them misinformation that threatens problems that aren't true if they leave the union? Why don't you want to shine the truth? The truth in this issue. Now, first of all, grievance representation. Just keep in mind, it doesn't happen very often. We keep talking about it.
How do you know that? Are you one of my members?
And it's a small factor in the whole thing.
Well, hold on. Hold on, Mike. That's an interesting
we're
assertion.
spending an awful lot of time on a minor topic.
No. But I think the minor topic is really important, because you may see it as a minor topic. I don't see it as a minor topic at all. For this express purpose. If I were a teacher, and this is something that is important. If I were a teacher, I would want to know who was the legal representative that was going to bargain for me or fix a problem for me. I wouldn't want to have any ambiguity there. That's why I have these guys here.
Is the point. That's all I'm trying to say. You have options
beyond
what's in this letter.
On Mike's, on Mike's assertion that it doesn't happen very often. Is that true?
No, obviously, the part of our representative, the nature of representative members includes the grievance and arbitration procedure.
Do you have a ballpark?
It depends on the local. It depends on where management is and where labor is at any given point of time. You could have 30 or 40 grievances in one local in a year. You could have only 2 in another.
Okay,
and a lot are resolved by our representatives at the lowest level. You never see them before an arbitrator.
So it's not unsubstantial.
It's not insignificant. Well, it's the same. We want people to be members of the union because we believe in the collective power of a united membership. But if you want to simply look at this as an insurance policy, it is as crazy saying don't join the union as it is saying, what do you need flood insurance for? You know, that flood only comes once in 100 years. Why do you need, auto insurance?
All right, that's okay. We're going to stop here. These broad arguments need to be made here in this conversation, but I'm going to do my best when we come back is to isolate this one sticky wicket, because I think it's important. Mike asserts he's right. Bob asserts he's not, and we're going to work through that and then get to the broader picture. Okay? Be right back. So at the crux of this, to be determined, small or not so small issue, with the new Janus ruling from the Supreme Court, is whether or not a public employee, for instance a teacher, can A, decide not to pay their union dues and opt out of that responsibility, get benefit from the collective bargaining that's been negotiated with the school department, But in the case when they have a personal grievance and or anything that comes up legally, representation is important to be correct, right? You need to be correct about that. The National Education Association Representative Bob Walsh here, let's show our guest again. And it makes sense to me, by the way, that if you're benefiting from the negotiated terms and then you want representation, that you should have to pay a la carte for it. Do you agree, Mike?
No.
Well, you're going to have to pay for a lawyer one way or the other. You got to pay for a lawyer, Mike.
What issue are we talking about?
What show are you on?
Well,
I mean,
what
are you
about
talking
representation?
I'm talking about
or
representation.
agency fees.
No, we're not talking about. I'm not talking about the bill, paying the bill to be in the union. No, let me finish. I'm talking about whether a teacher. Let's stipulate.
If it's negotiated in the contract, yes. If it's specified.
Can I just
in the
get a
contract.
point out? Okay, you're not fighting me, but it's going to end up that way if you keep it up.
I'm not allowed to talk today.
No, I have a point that I need to make to establish the argument. A teacher needs a lawyer. A teacher needs to pay a lawyer. Do we agree?
Sometimes.
Unless it's his brother.
If they're not a member and it's something under the contract, yes, that's what I say. That's what our letter said. You would need to pay
anytime I've ever
and I
needed
say
a lawyer,
a union lawyer. Right.
For anything,
right.
I pay the lawyer.
Right.
Okay, stipulate.
If you're a member, we got
And then you have to choose what lawyer it's going to be. That's where the argument seems to come here. You say that you must hire a lawyer sanctioned by the NEA because that's what.
To defend anything that was negotiated under the contract, under the four walls of the bargaining agreement, we defend the contract. If you are a member, you're covered by us. If you're not a member, you would have to pay a lawyer or a union representative, depending on the level of the case.
And then you
for
say, if you
representation.
want a lawyer for representation, it has to come from
Right.
your
We are the exclusive
auspice.
representative. We defend the contract. If something else happens in school, if you are accused of criminal behavior, that is not something necessarily we would provide, and you can hire your own person.
Gotcha.
Now, if there's a contractual impact of that criminal behavior, we get that piece of it, and you get the other piece of it.
Where's the argument now? You have the floor.
All right, there are third-party groups that provide legal support if they choose not to be a union member. So first of all, again, there are options. We're giving people options to make a decision. They can pay $800 a year to the union, and maybe they do that, or they can pay $200 a year and get liability insurance and representation if they want to join a non-member group. So there are options. Certainly,
that was before the Janus decision, Mike. That was private sector rules before the Janus decision.
No, if they choose
Page 17 of the Janus decision is very specific. We charge.
Good.
But finish.
It
But,
says you may,
I know the argument.
It says
it's
you
not
may
true.
charge. It also means.
Well,
that
and we're choosing to charge.
Okay,
Imagine that.
But that also implies, for the legal people, that they may choose not to pay your people and pay somebody else.
No, it doesn't. It's
Well,
not. It's not an option.
Well, if you're going to
It's
hold
not
this,
an
I can
option.
tell you
No,
this
no,
will be
no, no.
challenged legally
Of course
somewhere
it'll
in the
be
country.
challenged.
Somewhere in
You
the
guys
country.
challenge everything. You
Do we
challenge
think a
this.
person gives up their equal employment opportunity rights just because they're part of a union or not part of a union? And let's say a female employee gets harassed by her male counterpart. Now the union's at odds. I got two union members to deal with. They want to bring in a non-biased third party to help them. Even your own CBA says that level 1 grievances are not exclusive to the union. Even your own CBA says that. So this letter directly contradicts your own contract.
No, it absolutely
Yes, it
does not. Because, you know, it's actually what we tell members in reading their own contract when they say, oh, this doesn't say that. We say, keep reading. Now, for instance, you have rights under the Rhode Island Department of Ed as a teacher. And if you read the next line, the very next line, NERI will not assist you with right hearings or appeals. Hey, you want to bring in your own lawyer? Have at it. That's not covered by the contract. That's covered by statute. Someone violates your statutory rights and you want to pay $1,000 or $10,000 to a lawyer where we would have protected you. You want to go before the retirement board where we will represent you?
Employees
Hire
have
your own
legal
lawyer.
options.
Have at it.
Employees have legal options.
Not
I'd really like
under
to
the
discuss
four
the
walls of
broader
the
issues here.
contract. Not under the four walls. of the
I don't know why we're stuck on that.
No,
it's
because we're
a
stuck on it
disagreement
because it's unresolved and it doesn't.
And by the way, you brought it up.
Hold on.
This was a letter we sent to
This
our
letter
members,
is
and you
misinformation.
brought it up.
Lawyers say this is an outrageous piece of
What lawyers?
misinformation.
What
Do
needs?
you want the letter? Do you want the
Let me
letter?
see if I
Sure.
can do this one
That
more
would be
time.
There it is, right here.
I'm
I
going to
sent-
see.
I
I'm
sent
going
it
to
your
see if I
staff
can do
here.
this one more time.
Right here.
I've seen the letter.
Okay.
I haven't seen the letter.
Are you not stipulating to the idea that inside the four walls of the contract, for representation and grievance about contractual issues, that a teacher would have to hire one of his lawyers? Are you not stipulating to that? Because that's the simple thing that I'm looking for here, one way or the other. Are you arguing that that's not the case?
I don't know for sure. Okay, I'm not a lawyer. I'm not a labor expert. I'll concede that point.
But your point
but
in the original discussion,
employees have rights outside. This letter tries to make it seem these are your only rights and you have no other rights. It's misleading in that way. People do have other rights under other circumstances.
It specifically says if you want to file a grievance can only be initiated under the contract. We defend the contract.
And in your CBA
it's
says
very,
in level
very
1,
specific.
You're not exclusive in level 1. Your own CBA says that.
Well, that makes perfect sense. So I don't understand what you're suggesting.
That means they're allowed to bring in someone else under a level 1
But there should be an already understanding for employees in this state that if there are legal issues that are outside the exclusive bounds of the contract, that they have the freedom to hire any lawyer.
That's always
been
the
the
sake of this,
case.
I'll concede, because there's much more important things.
I'll take the concession and we can move on to another topic.
It's not often that the guests on this program would suggest that what I invited them in here for is not worth their time.
No, I think it's worth the time.
We'll come back and talk about the bigger picture, I guess. The point of the matter is that it seems to me that he's affirmative and you're not sure, and so the audience can determine
the Janus decision created some
who's
gray
correct
areas
on
that
that.
have yet to be resolved.
We'll get to the bigger picture when we come back. The broader picture of this conversation about since this Janus decision, the Supreme Court decision, which really creates, do we agree, kind of an all or nothing dues paying type of deal.
That agency fee status is gone. It's all
you put out an op-ed that caused the conversation at the beginning, Mike, that you say the headline, and we didn't pop the headline up, but the headline you say was incorrect, that you're not encouraging union members not to pay their dues, you're advising them as to what their options are.
It was the Projo story, not my op-ed.
Okay.
On our
story.
Yeah, so Part C, when you did A, B of the Janus decision, Part C is also they can't be discriminated against or recriminated against if they choose not to join the union. Right? They have the freedom to choose. I think Bob.
I agree with that.
Bob would agree with that.
No one can be discriminated against for choosing or to join or not.
So what's the gripe?
So the gripe is we have anecdotal evidence, and I have to tell you it's anecdotal. We believe there was a second mistake in this letter, which we can talk about later. We believe when the governor came out and said we don't want public employee contact information going out there for groups to contact them, when the Attorney General last week put out a statement against us trying to discredit our honest and truthful information. There's an effort out there to keep, just like I said at the top, to keep public employees in the dark so they feel threatened, like, geez, if I leave my union, I'm in trouble. Well, that goes against the whole spirit of Janus. And then when you add in the political spending that unions make, both politically, for their own staff, and if public employees are aware of what's really going on in the union, now they can make an informed decision, and we trust them to make that informed decision.
We've always trusted them. See, the thing is, what you're missing is, because I've been in the game for 25 years, and you guys are kind of late to this game. The agency fee status already gave those choices in a different way. You are younger. The agency fee status already gave those choices. This is just a different set of choices. So the first few things in this were the same either way, agency fee or member, non-member, because agency fee payers in the past couldn't go to membership meetings, but we did represent them. Really, and what we're doing is informing people of basically the change in the fee
I just want to make
structure.
sure that everybody understands the agency fee was the proportional payment for union representation that excluded political and charitable. And it was 85-15, right? So it was a fraction of 15%.
In Rhode Island, it's 85-15.
And no longer, it's an all or nothing. I got to tell you,
so
somebody who's not a teacher and Bob would say this, I don't know that I'd line up on a whole lot of issues with you over
I would
the past.
agree that we do not agree on a lot of things.
I don't see the fairness of the Janus decision in the sense that if I'm a teacher and I benefit from the entire compensation and other issues involved in collective bargaining, that I didn't contribute to that cause. So I'm having trouble digesting the legitimacy of that.
So this was specifically addressed in the Janus ruling. Janus ruling said it is far more egregious for people to be forced to pay to a union they don't want to belong to, especially when it involves a political activity they disagree with, and that for 30, 40 years, Alito said this in his decision, for 30, 40 years, unions have been unfairly collecting money from people who didn't want to be part of that union if they were employed in certain occupations. So they say that carrying the free rider clause now, don't complain given that you've had 30, 40 years of a free ride unions.
All right, so in other words, there's money in the bank that you didn't deserve, and so you got to take the hits.
But you know, the funny thing in constitutional decisions, that's not how they work, because for that 40 years, to Justice Alito's great dismay, the law of the land decided by the Supreme Court was agency fee was constitutional under the Abood decision. So everything we did, now they changed the rules of the game. They put in a designated
now that's the law.
to give you the baseball analogy, but you don't go back and replay all those games, right?
So
you say, all right, this is a new rule.
Gotcha.
You don't go
we
back
only have
and
a
play.
couple minutes.
And I don't even know if I like that designated hitter.
You guys have an obligation to market the union more aggressively to the members.
Sure. I mean,
you guys are suggesting what? That they're not being truthful in the marketing? You each get like a minute on that.
Can we put up that cartoon I brought you? We believe that education especially will benefit from this, because now, take teachers, just for instance. Teachers now, if the union is doing things, whether it's in their political spending, their collective bargaining agreements, other contractual arrangements that teachers don't like, they can't count on their money automatically anymore. They have to market to teachers, which means teachers now have a greater voice. So we're encouraging teachers to speak up. What do you want to see different in your union about their political spending, about their bylaws? I know they get to vote on things right now, but they don't get to vote on the political spending you guys make.
Sure they do. They absolutely do.
So teachers have been empowered. Teachers are empowered. We expect them to use that, but unions are going to have to start marketing more to their own members.
Yeah, and there's nothing wrong with marketing more to your own members, and I would contend we've done that already, and people are fully aware. We're the most democratic institution in the state of Rhode Island. We've got 75 locals. Every local president sits on an executive committee, which meets 7 or 8 times a year. We've got a delegate assembly with 300 or 400 people, that one for every 20 of our members, that has voting strength to decide the dues level, the budget, where the money goes. Our political action committee is separate. That's a separate committee where people kick in $10 each, and if they don't want to, they get their $10 back, that do the endorsement part of the organization. And of course, people disagree. There's a subset of our membership that don't disagree with everything. They wanted this in the contract, not that in the contract. They would have preferred this candidate to that candidate. But that's the way it is that's the way it is in both political parties and just about every other walk of life.
So
we don't like this decision, but it is now the law of the land, and we will move forward under it. And we like talking to our members, so we're just going to keep that dialogue going. We're very happy with
it seems
our
to me.
membership.
It seems to me that you should read the positions of the Rhode Island Center for Freedom and Prosperity. Read the positions of the National Education Association if you're a public employee. Read the Janus decision and be informed as to what your dues-paying obligations are, your options are, what your rights are, and don't take things for granted. True?
Fair enough.
Fair enough.
Good. Was he a good pitcher or not?
Was a hitter.
He was a hitter.
Thank you.
You were a hitter. You weren't a pitcher.
No, his father was a pitcher. We talked about that last time.
It was my mistake.
Yeah, but
Final word.
you weren't saying my dad was
back.
No,
my
my dad was
it was-
terrific.
I
I said your dad was
dad
terrific.
that was
And he
the
deserves
pitcher.
it.
Tomorrow night, we'll revisit a really interesting conversation on social media law that I think is interesting. It's played before. We're going to take a little day off before the primary. Then we'll be back on Wednesday night with an original program. All right, so thanks so much. Did you get all that? Teachers, public employees, do your research and take your notes. Thanks for watching. Good night.